Hello, everybody, and welcome. Hopefully you can hear us. This is Keith O'Donnell from Taxand, Luxembourg, which is ATOZ. I have with me here Desislava Dimitrova, and we are hosting this along with our colleagues from Spain and Italy. If you just briefly want to introduce yourself, Alvaro, hopefully we'll see you popping up on the screen.
Yes, thank you, Keith. This is Cueva. I'm from Taxand, Spain, Garrigues, and I'll be pleased to comment on the Spanish developments in the withholding tax reclaims in Europe.
Okay, and Guido and Erminia, do you just want to introduce yourselves too?
Yes, please, Erminia.
Hi, everybody. My name is Erminia Procopio, and I am a tax manager here in Taxand in Milan.
Hi, my name is Guido Arie Petraroli. I'm a partner here in Taxand, always based in Milan.
Very good. Okay, so welcome everybody. Just a few comments on how this session is planned to run, technology and everything else willing. We will run through just some comments on withholding tax reclaims in Europe under Article 63. We have themed the session Down the Rabbit Hole, a very obvious reference to Alice in Wonderland. Why down the rabbit hole? Because for those of us who have been at this for 10 plus years, we feel we're still falling down the rabbit hole. We're discussing things as we fall down. We discover things as we go down. We are making progress, but there is sometimes a distinctly surreal edge to it. Hence Alice in Wonderland. During this session, if you'd like to ask questions, please just type them into the chat box. Hopefully we will see them and we will try to respond. We should be able to see them appearing. If you don't get an answer immediately, please do bear with us because sometimes it takes a while for those questions to get to us. In general, as participants, you will all be muted just because there is a rather large number of us, for which we are very grateful. So please do make those questions in writing rather than verbally. So let's start off down our travel down the rabbit hole, and we'll start the panel by running through an introduction to the subject. So how we got here, and talk about briefly why we're sitting here in front of you, this particular group of people. And then we will also then get into two particular countries which we thought would be interesting to address today. That's Spain and Italy. We'll talk about why Spain and Italy, but partly because they are both markets that are quite active, and at the same time we are reasonably optimistic about the future. Contrary, we might say, to some other countries where we're distinctly less optimistic. So on that idea of being a bit more cheerful, we thought we wouldn't spend too much time on some of those. And at the end, we will have a Q&A session. I did see a question flashing up there. Is there a presentation that can be downloaded? I believe this presentation will be made available to the ICI, but I'm not sure if there's a way to download it right now. So with that, let's start off about how we got here. So first of all, a little bit of background. Article 63, as many of you will know, is a critical article for our purposes in the European Treaty. So that's the foundational treaty of the European Union. And Article 63 provides that in order to encourage free movement of capital within the Union, there should be no restrictions to the free movement of capital within the Union, but also without the Union. So it also applies to so-called third countries, which is a slightly unusual provision because it basically seeks to have a type of extraterritorial effect. The history of this is slightly obscure, but it's generally accepted that this was done with an intention of creating a deep and liquid capital market within Europe, and therefore it was considered essential that individual countries within Europe could not create, for example, exchange controls. And that's probably what they had in mind. Generally, the tax side of the European treaty started to emerge later when people pointed out that taxes could also be restrictions or barriers to the free movement of capital or the other free movements, so labor, goods. And in the same way as tax became an issue for the treaty generally, it also became an issue for Article 63. So what this actually means, if you look at the fourth little flag, is that from a tax perspective, a member state cannot tax a foreign fund more than a comparable national fund. So if, for example, France chooses to give withholding tax relief to its own French funds on a dividend paid by a French company to a French fund, it then also has to give the same relief to a dividend paid to a foreign fund that is in a comparable position to that French fund. Now, this all sounds relatively straightforward, but it does get a little bit more complex than that. And to put it in context, to actually get significant reclaims out of France, which started to be made last year, it took close to 10 years, basically, despite this being a relatively simple provision. And if we just focus on the case of France, why it took so long, it's probably a good indication of why some other countries take so long. First of all, at a very simple, basic political level, many EU member states feel they never signed up for this. So when they were signing the treaty, they did not realize that this would be one of the consequences, that they couldn't tax foreign funds more favorably, less favorably than their domestic funds. So that's the first thing. Politically, at a certain level, member states were surprised. They weren't happy about this, particularly when they found themselves potentially having to refund billions of euros to foreign funds. The second point was initially they all presumed that it was only applicable to intra-EU dividend flows. That's to say France couldn't tax dividends paid to a German fund less favorably, but it hadn't really sunk in that the same could also potentially apply to a non-European fund. And a lot of European member states were particularly upset about this because they said, for example, if we give this relief to non-European funds, we get no reciprocity, basically. So a French fund investing in the US, for example, doesn't get a reciprocal relief. But again, that was a choice that was made when the treaty was drafted to create a deep, liquid capital market in Europe. So although they don't like it, and to some extent, some of the behaviors like children throwing toys out of prams, it is what it is, and we've just moved on with it. So that was another step that needed to be taken and needed to sink in among the member states, that this did also apply to non-European funds. In our case, obviously, US funds are particularly important. And then the final step, perhaps, is the concept of comparability. So you can't discriminate among funds that are comparable. However, if the foreign fund is not comparable, then you could seek grounds to discriminate. And it's no surprise that many member states have sought to argue, first of all, that foreign funds were not comparable. There was one particular decision, DFA Poland, where this was put to bed, in that many member states in that case, filing friendly briefs, tried to say, well, within the European Union, there is a common regulatory system for investment funds, the so-called UCITS directive, undertakings for collective investment in transferable securities. And all the European funds basically follow this directive. Therefore, they are comparable. However, a foreign fund is not covered by this directive, and therefore it's not comparable. And although the Advocate General who writes the opinion for the court and is generally followed in that particular case showed quite a lot of sympathy for that argument, the court dismissed it quite summarily, saying no, because if you did this, basically you deprive the extra EU effect of the article of any meaningful purpose or any meaningful effect. So that was kind of one of the final stages in getting us to where we are at the moment, which is that most of the key principles have been established. And we're now in a position where a lot of the action has shifted from the European courts to the national courts. And that's why we'll spend some time on some of the key countries where the national court decisions start to have importance. And you might ask why the national courts have relevance. Well, the basic principle is, as on matters of European law, the European court is sovereign, and European law is sovereign to all, or superior to all, the individual member states' laws in case of conflict. However, beyond the principles of European law, what the European Court will generally do is it will send back decisions to the national courts to execute, basically. And they do have to execute in accordance with EU law, clearly, but there is a discretion in the execution. And this is where we've got into some quite gnarly discussions in certain countries about how exactly they should be applying European law on a national level. So with that, let's maybe move on. And maybe what we could do at this point, and Desi, I'll let you do this, is have an overview of the different countries, the different status, and where we think they may go in the future. So why don't you take us through that?
Sure. Well, as Kate mentioned, the Article 63 creates this possible discrimination throughout Europe. For the time being, and throughout the life of the withholding tax project, we identified 12 to 13 countries at the times that where such discrimination exists. And as you can see in this table, those are the markets where we know that discrimination exists and where we are active for the time being. So if we start well, alphabetically, we have claims in Austria, Belgium. So maybe country by country. Austria, well, you may already heard recently there was a quite important Supreme Court decision. As Kit also mentioned, local courts are very important in this process. So it seems that maybe the chances of success in this country will shift in the next months, but this is to be seen what the reaction of the lower courts will be. We have also Belgium. Quite interesting recently, we managed to initiate some further proceedings, and exchange of information procedure was initiated by the Belgium authorities, which is a very good signal that our claims are being looked at. We have Denmark. Well, not that great in the recent months. Probably everyone heard about the recent decisions following the European Court of Justice decision from a couple of years ago. So yeah, that's why it's in yellow and not in green. But again, the developments will follow probably in the next months. We have Finland and France, very interesting markets, which proved to be very successful for the withholding tax reclaims, especially France. Probably everyone heard of this great large refunds and interest payments that were done by the French government in the past months. They started approximately a year ago in August 2020 in the middle of the COVID crisis, and they keep going. We have Germany and Italy. Well, Germany is quite inactive, although very interesting for investment from a US perspective. However, up to now, it doesn't seem to be too much activity on our claims. Italy, as we mentioned in the beginning, we have our colleagues Erminia and Guido today, who will be talking about Italy and the latest developments later on during the presentation. So we come to Netherlands and Norway. Well, with Netherlands, similar to Denmark, there were quite disappointing decisions issued in the past several months. One of them specifically for US regulated investment companies. So the Netherlands specifically seem to be a market where the withholding tax reclaims should or might not be very successful in the next years. The Norway, well, the Norway is on the list because it's a country which is part of the European Economic Area. However, it's not part of the European Union. Therefore, the Article 63 is not binding for Norway. And while we tried to file and be successful with our withholding tax reclaims, it was proven that it's not going to be the case. We have Poland, also very successful, similar to France, but a couple of years ago. Again, following exchange of information procedure and European Court of Justice decision, the country paid significant refunds to US regulated investment companies. We have Portugal, which is a market open for filing withholding tax reclaims only for a couple of years now, or actually already 3-4 years now. For the time being, we don't have any success, any big successes there. However, we are very positive that it will follow probably similar development as Spain. We have Spain, and Alvaro will tell us about the recent developments shortly. And of course, Sweden, although the last years were complicated and not all the time successful, after the big refunds that this country paid in the course of 2015, followed by some controversial decisions, now they're back into a very good track for the withholding tax reclaim. So hopefully we'll see some significant refunds in the next months. So that are the countries covered by our project.
Yep. And I think maybe it's worth just adding on the Netherlands, because I think there's been quite a lot of questions among ICI members about the capacity to either continue filing in the Netherlands or even to keep existing claims alive. We've looked at this in a lot of detail and we've discussed it extensively, both with our colleagues in the Netherlands and also with the Dutch community more broadly, the Dutch tax advisor community. And the general consensus is that the path to success at this stage is so narrow and so long that most claims, if not all claims, have been dropped. So far, we've examined countless claims, and in every case so far, our recommendation to clients has been to drop them. And the reason for doing that is that we think that although we could disagree with the recent case of the Dutch Supreme Court, it's hard to say it's completely wrong and that it can be overturned, firstly. And secondly, in order to take that case back to the European Court of Justice, it would take an inordinate amount of time. And it's very clear that for existing claims, to keep them alive during the period of time, which could be up to 10 years, where a case might be taken to the ECJ and be successful, the Dutch tax authorities will push all those cases into court and try and make them as expensive and complicated as possible to keep them alive. So our view is the path to a possible victory is just so narrow and so expensive that we generally are not recommending it to any of our clients to pursue it. Denmark has a similar tax system in some ways, so has some similar issues, but we don't think there the path is as narrow. We're still analysing that to see whether cases could be pursued with a meaningful chance of success, and we think so far there are some that are worth pursuing. So maybe with that, just a few words about why are we talking to you here. The team you have in front of us are a selection of the Taxand team, which have been working together on European withholding tax reclaims for US, Canadian and EU funds, with a particular specialization on US funds. And we basically, within the Taxand team, Taxand covers about 50 countries overall. We've obviously focused on the European side of things here, and we've assembled a team which includes litigation lawyers and tax specialists across the 12 most significant markets. And basically, we've developed a common market, a common approach, a common team, and also tried to align our billing models with the way that serve investor interests, as well as the other stakeholders such as trustees, management companies, advisors, etc. So we will jump in now to Spain and Italy. Maybe a brief word, why did we pick Spain and Italy? We picked Spain and Italy because Spain, the refund process has just started. However, there's been a number of significant court cases which Alvaro will comment on. The Spanish court system is also quite complex, and that's why also we feel it merits a bit of time. And then as regards Italy, there was a change in law as of 1 January 2021, which seems to have been the acceptance by the Italian authorities that the Italian withholding tax that had been levied in the past should not have been levied. However, the change in law didn't fully deal with all the issues, firstly, and secondly, there is as yet no acceptance that withholding tax that was levied in the past was incorrectly levied, and therefore we're heading into a court procedure. So that's why we picked Italy and Spain for this particular presentation. We thought they were interesting. And with that, I'm going to hand over to Alvaro to take us through some recent developments in Spain. And Alvaro, if you just tell us when you want to flick through the slides, we'll flick through them here from Luxembourg.
Thanks a lot, Keith. Well, the Spanish situation, as Keith has rightfully pointed out before, is one of the perfect examples of how to make up inconveniences and requests from the Spanish authorities trying to delay as much as possible refunds and trying to design strategies as to try to keep that money that Spain never considered that was improperly levied on the funds, right? This has been the situation for many years until on November 2019, the Spanish Supreme Court solved the matter. Basically, the Spanish Supreme Court was ruling on the application of Article 63 of the Treaty on Functioning of the European Union. The key argument here was that since the Spanish law had never established a specific procedure for non-resident taxpayers to avoid restrictions under EU law, then it was a problem of Spanish law, and it was not a problem of the funds. Therefore, it was sufficient for the funds to provide reasonable evidence that they were comparable with a Spanish resident investment vehicles. Okay, that was the main criterion, and this is what we've been using in refund requests. Since there were already at least 2 decisions that created jurisprudence under the Spanish constitutional system, and accordingly, the Spanish authorities and all courts were obliged to follow this unless the Supreme Court changed their view. Initially, the Spanish authorities indeed began following this. The main administrative tribunals, which are part of the Spanish tax authorities, began ruling in favor of US funds, and the US funds got some significant refunds, including also some Canadian funds on some other types of US funds, which are not the typical mutual funds. Okay, this was the scenario. Suddenly, in July 2020, when the National Court had to start ruling, we had kind of a surprise. Before moving on to the next page, let me explain you something. In Spain, the refund system goes first to the Spanish authorities, afterwards to the administrative courts, which are not a proper court, but part of the tax authorities, and afterwards they go to the National Court. Okay, the National Court is a lower court, but is in principle specialized in taxes. Any decision from the National Court may or may not be appealed to the Supreme Court, because for the Supreme Court is for the Supreme Court to decide whether the case is interesting enough for them to hear it. In fact, only 20% of cases make it to the Supreme Court, and 80% are dismissed on the basis of non-interesting. Okay, so we had the case where the National Court was in principle bound to follow the doctrine of the Supreme Court. And in the first decision, they had to issue this. If we can move up, Keith, please. Then we got a little surprise. one of the judges of the panel introduced a new criterion, which, in the view of the judge, had not been properly addressed by the Supreme Court. In the view of this judge, on the possibility that US funds had to deduct foreign income taxes, foreign withholding taxes when filing the corporate income tax return was enough for them to neutralize the discrimination, because they were actually getting some kind of refund in the United States. Okay. Fortunately, this was the opinion of only one judge. The rest of the court was of the opinion that the fund was entitled to a refund unless the Spanish tax authorities proved that the withholding tax had been actually recovered in the country of residence. And this proof had to be substantial and had to be real, while in all the cases that we have waiting for a decision of the National Court from year 2006 onwards, the Spanish authorities had never taken any action to prove that the fund had actually recovered any amount. Therefore, in the view of the majority of the judges, the fund was unduly discriminated. The Spanish authorities had not taken any positive action to prove that the Spanish withholding tax had been actually recovered, and therefore, if you don't prove anything, then it doesn't have to weigh anything. Okay? So this was the decision. Problem was that the state attorney took the opinion of the dissenting judge to the Supreme Court again, trying to overturn the previous two decisions of November 2019. Okay, if we can move on, please. Basically, as mentioned, the state attorney took the matter to the court, and we had to take the stand to defend that actually the decision of November 2019 had actually addressed the issue. It was only that, sorry to say, the dissenting judge had not understood completely what the Supreme Court was saying. We were lucky, and the Supreme Court confirmed our position in other 3 decisions of December, January, and April of this last year. Okay. Additionally, the Supreme Court also dismissed the appeal of the state attorney, so we can say that that unfortunate case of July 2020 is now closed at the judicial stage. However, the state attorney is doing something which they do only on a very, very few occasions, which is trying to issue an appeal for reconsideration. The importance of the appeal for reconsideration is that it's based on the fact that, under the view of the state attorney, the court has not addressed all its claims, and therefore is creating a problem with their right to a constitutional defense under the Spanish Constitution. So it seems that they could be pointing to the Spanish Constitutional Court on this matter. To be sincere, we really believe that this is just some kind of deferral tactic. Okay, we don't see that this case has any merit before the Constitutional Court. If the Constitutional Court decides to hear this, it will be only on the fact that the court, when rejecting the admission of the appeal, did not address all the points that had been written by the senator in the appeal. It should not go into the merits of the case. So actually, we believe that this is just some kind of tactic in order to avoid starting refunding on these specific cases. This is something which we should know in the next months, because this is for one case, but there are many other cases still waiting at the National Court. Specifically, there is one big refund decision, which is a test case grouping nearly 40 different cases from US funds, which is still hearing, still being heard by the court. And the court has requested the Spanish authorities to give their view on whether this test case merits the same treatment as the Supreme Court cases. Basically, the Spanish authorities, needless to say, are saying that they don't, because the Spanish taxation has been neutralized in the US, and we are saying that this has already been solved by the Supreme Court in all these decisions that you have on the screen, and that therefore the court has to rule in our favor. We should know more in the coming months. What does this mean for past and future claims? To be sincere, we are quite confident for past claims until year 2014 approximately. Those are claims that are currently being debated at the National Court, and we believe that a positive decision and a refund should be coming up for all those cases. For claims of year 2015, some of them are at the National Court, some of them are still at different stages. The Spanish tax authorities have taken a complete, or the usual obstructive situation, the obstructive position. Basically, they are now refining the request. They are requesting US funds to submit, for instance, proof of their taxation by submitting copies of the 1120 tax forms, so submitting copies of the 1099 div tax forms, and by explaining what is their legal status and how they are set up, who are their investors. They are preparing a big questionnaire and asking us. On the other hand, something that was very much in favor of the taxpayer, as I mentioned, was the fact that the Spanish authorities had never taken any action to actually prove that the fund was actually non-taxable in the US on Spanish dividends. The Spanish authorities are still refusing to enter into exchange of information procedures with the US, which in our view is good for the funds, because it's really going to be something that the court will really put onto them when they have to rule on the definitive case. For future claims, as mentioned, we should still see some referrals. We'll probably have to go again to the Supreme Court for years 2016 and onwards, but chances are pretty good, and we are still confident that it should be solved in a good way for US funds. And,
okay, thanks, Alvaro. Just a question. I mean, I understand that the neutralization theory has been rejected, albeit implicitly, and it's still, to some extent, as I understand it, you said it's partly because the tax authorities themselves did not bring evidence of any neutralization, so it kind of became a burden of proof issue. Between the Supreme Court cases and the other cases, do you see that they, you mentioned it was the neutralization theory was never fully accepted by the ECJ. Now, clearly in the case of France, the neutralization theory was basically rejected, and it was rejected because the French tax system did not look at whether or not withholding tax was neutralized at investor level. The French tax system said, if it's a French fund, there is no withholding tax on the dividend, period, basically. If you were to look at the Spanish tax system as it applied before or after 15, and the way the withholding tax is relieved for a Spanish fund, is there any element of the relief being conditional on non-neutralization at the level of the shareholder, or is that implicitly the case just because of the construction of the Spanish tax system? Do you understand the question?
Yeah, absolutely, and your point is very good, because Spanish tax system doesn't make the taxation of the fund dependent on distributions to shareholders or on the taxation of the shareholder itself. It's just a Spanish fund, period. You're just receive a 1% tax rate. So there is no point at all pointing to the taxation of the fund itself, because that's not what the Spanish law does. It just says, okay, you just meet certain regulatory requirements. You are just an open fund. You are just available for investment by professionals or by general public or whatever. You have several legal requirements. You meet them. You automatically are use it. Automatically you get the 1% taxation. So therefore, this is why it's so important for us to show that US funds actually have similar legal regime to this Spanish authorities, that they are open and that they meet the basic requirements provided in the UCITS directive.
Mm-hmm. Mm-hmm. Okay, thank you, Alvaro. Then I'd suggest we move on to Italy, and let me just move the slides on. And Guido and Erminia, do you want to take us through what's been happening in Italy?
Yes, just one step back, coming back to slides, the general slides that you show, that was also highlighted Italy. As you know, we have already started a long time ago procedures of a refund for the funds. And the situation now is that we are at the Supreme Court level waiting for any sort of decision. In Italy, the system is quite well similar to the Spanish one, but not so similar in the way that first there is a request of a refund. The normal approach of the tax authority is the silence, and then after that there is a procedure that involves the first tax court, the second tax court, and finally the Supreme Tax Court, the Supreme Court. As you know, for some investors, we are at the level of the Supreme Court. It's absolutely true what you said before, and this helps us to understand which is the situation. In other terms, when this procedure of refunds started, there were a lot of obstacles that have been put by the tax authorities in order to get the refund. First, it was the lack of documentation. In other terms, the documentation were never sufficient. Then, when they realized that this was not something that was working, they started to issue questions that the issues raised were really very high in terms of also of amounts involved, and therefore that the question of the refund should have been solved not at the level of tax court, but a level of a communication or of a letter of a tax authorities or a precise indication of the government. And this, of course, did not happen. And in Italy, there are not also other Supreme Court cases that we can consider as a route in order to get the refunds of the clients. So in this situation, we are honestly quite the sort of pioneers in this sort of request of refund. Now coming and therefore it's something that it's really a development, and probably we are comfortable, we are optimistic that the Supreme Court will come to us and to the client, because we really think that we have more than different reasons to obtain the refund. In any case, the next decision of the court will give a route also in order to understand what is wrong, what was right, and a sort of route in order to understand which is the thought of the court on this matter. Going forward and going to our specific issue of the free of movements and this, it's important for us. It's important as written here in the slides. in the 21 in the budget for the 2021, it was introduced a new provision that gives a sort of tax exemption to a certain typology of investment. Before going to the detail of the two main issues that Erminia will highlight is to understand which kind of investors benefit of this tax exemption. Basically, they have to have, we have two conditions. The first condition regards the type of foreign investment funds. Since the withholding tax exemption is applicable only to certain type of funds, that is foreign, what we call OICR, that is OICR, that basically it's the UCITS, what we call a UCITS directive. The second typology of funds is foreign, always OSCR, not established in accordance with that directive, but somehow subject to a form of supervision in the foreign country where it's established, the AIFM directive. The second condition, this is important, and it's linked what Erminia will say now, regards the state of setup of such OICR. We should be a European state or a state belonging to the what we call the CSEE, that is the countries Norway, Iceland, and Liechtenstein. Just one point for the reference to the state of incorporation, that also in the case of OICRs managed under the AIFM directive, it's relevant only the place of incorporation of the fund. For such purposes, it's not relevant the place of effective management of the OCR or the place of incorporation of the management company, which could be located also in a country other than the state of the incorporation of the OICR and managed through, for example, through the passport. We have basically two issues that Erminia, let Erminia explain, and where we probably could work in order to help to get a refund, because this is something that there are some critical situations also regarding these new rules that at the first glance seems to solve the issues, but in reality many issues come also out from these new rules.
Yes, as just mentioned, starting from January 1st, 2021, no withholding tax will apply on dividends paid to companies to investment funds that are established in the European Union or in the European economic area in a country that allows a proper exchange of information. The amendments to the law made by the budget law for 2021 were specifically aimed at eliminating the discrimination between Italian investment funds and non-Italian investment funds. The discrimination derived from the fact that Italian investment funds are exempt from corporate income taxes, and therefore they do not suffer any taxation on dividends. On the contrary, dividends paid by Italian companies to foreign investment funds suffer a withholding tax at the 26% rate provided by the domestic law, or at the reduced rate provided by the double tax treaty. In this different treatment clearly represents a discrimination between Italian funds and non-Italian funds, and represented a violation of the free movement of capital, which applies to European countries and to non-European countries, and under which all the restriction between European countries and between European countries and non-European countries are not allowed. In the past years, the European Commission started to investigate the Italian legislation, and to avoid the starting of a formal infringement procedure, Italy decided to amend the tax law. As mentioned by Guido, even if, of course, the amendments are a good starting point, there are still some critical aspects to be considered. First, the timely effect of these amendments. As mentioned, the amendments only applies to dividends paid starting from January 1st, 2021. They do not, the withholding tax exemption do not apply to dividends paid before that date. However, since the amendments were specifically aimed at eliminating a discrimination that existed also before January 1st, 2021, there are no reasons why the dividends paid before that day should suffer a withholding tax, while dividends paid from January 1st, 2021 would be exempt from taxation. From a practical point of view, it's important that investment funds who suffered withholding tax on dividends paid by Italian companies file a claim to the Italian tax authority to ask for the refund of the withholding tax suffered in the last 4 years, since the deadline in Italy to file a reclaim is 4 years from the payment date. It's also useful to say that in the past, when Italy amended its law to eliminate a discrimination between Italian companies and non-Italian companies, the Italian tax authorities granted the refund of the withholding tax, even if the law that was at that time amended did not apply to dividends paid before the entry into force of the law. The second critical aspect that is very important is that the provision only applies to foreign funds that are established in the European Union or in the European Economic Area in a country that allows a proper exchange of information. Non-European funds, like US funds, are excluded from the scope of the new provision, and therefore they still suffer a withholding tax on dividends paid by Italian companies. This different treatment clearly still represent a discrimination between European funds and non-European funds, especially if we consider, for example, non-European funds that are comparable with European funds and that are, for example, subject to a form of supervision and that are established in a country that allows a proper exchange of information with it. So in our opinion, this exemption from withholding tax on dividends should also apply to non-European funds. Otherwise, another violation of the free movement of capital will occur. In this respect, we take this opportunity to say that the Taxand network is assisting the preparation of a filing and the filing of a complaint to the EU Commission to notify the existence of a discrimination between European funds and non-European funds, and that results clearly in a violation of the free movement of capital.
Thank you, Erminia. So I think that's very interesting, because I think it shows that there is effectively this recognition that withholding tax is unfairly applied, but at the same time we still have this kind of grudging lack of acceptance that it should be made available to third countries. And I think that's the purpose of this complaint. I think the complaint should help for the future, because logically the Commission, if they take up the complaint, should request Italy to extend the relief to non-US funds. But clearly this change in law won't be binding for past taxes, so we will still need to go down the litigation route. However, it'll clearly be helpful if we have law change and potentially European Commission complaints that do indicate that the past was already illegal under European law. So I'm conscious of time. We had a few questions coming through, so hopefully we've managed to address them directly or to everyone in the group. But maybe just by way of wrap up, where we are now in our journey down the rabbit hole, I think it's fair to say overall the industry has had great success, even though it was hard fought over the last 10 years. We were recently doing the count, and we believe that we've now obtained refunds in excess of 2 billion for US RICs and their investors, which we think is huge progress. And frankly, if you'd asked me 4 years ago, I wouldn't have guessed we'd been here. I think we still have a lot of work to do going forward. Some of that work is just you know, the hard work of dragging things through courts and tax authorities, where we think it's ultimately a question of time, but we think we should succeed. And then there are genuinely still some more complex technical issues, such as those encountered in the Netherlands. And to some extent, there's a similar issue in Denmark, though we believe it's more straightforward. What I would just say as a final kind of comment is that it's a long process, but definitely worth pursuing. I think there's been, you know, tremendous cooperation in the industry, and I think the ICI has done a great job in coordinating all of this, because it's clear if you have, you know, hundreds of funds making thousands of claims all around Europe, there is the capacity for things to go wrong or to be inefficient. And I think the industry as a whole has shown great sense of solidarity in doing this together and sharing information and updates, etc. And I hope that, you know, if we speak again in another year, maybe we'll have another country that's on a clear path to refund, and the next year another one, and the next year another one, and then at some point all the people involved in this, we can all move on to do something else. I think that's probably the utopian vision. However, I think we'll still be down this rabbit hole for some time to come. So in any event, thank you for your attention on behalf of Taxand and my colleagues here on the presentation. And if you have any questions or comments, feel free to reach out to us. Our details are in the presentation, which you'll be able to get from the organizers by way of download. So thank you all, and have a very good rest of your conference. Bye-bye.
Bye. Thank you.